Well, welcome everyone to MLAW's virtual 2021 Legislative Wrap-Up Happy Hour. My name is Michael Cohen, and I'm the president of the MLAW Board of Directors. We are delighted to have so many of you join us today, and I expect that we'll have some more joining us as we go along. Again, for those of you who may not be familiar with us, MLAW is the only statewide coalition of women's groups and individuals that provides a nonpartisan, independent voice for Maryland women and families. We mobilize networks, groups, and individuals from all over the state to ensure the passage of key legislation. And every year, the Maryland legislature considers hundreds of bills, and every year, a high percentage of MLAW-supported bills become law. These laws make a difference for women and families throughout Maryland. Since 1994, MLAW has supported 101 successful pieces of legislation. In 2021, 4 of 7 bills on the MLAW legislative agenda passed the General Assembly. In addition, we supported the override of 2 vetoes of bills from last year's agenda. MLAW support does make a difference. As you all know, we produce and distribute a legislative agenda document to all legislators and advocates throughout the state. The legislative proposals included on the agenda are voted on by our paid members. During the session, we introduce and disseminate the agenda document. We collaborate with lead groups and legislators. We write letters of support, provide testimony, and provide information, updates, and legislative alerts via email, our website, and Facebook page. After the session, we create a final report with the legislative outcomes. You've been sent a link to the report, and I encourage you to print it out and to follow along with, as our board members, local group lead group advocates, and legislators describe what happened to each bill. Before we begin these presentations, I want to take a moment to remember board member Linda Mahoney. And Jessica, can you put up that photo? Thanks. In March of this year, MLAW lost one of its longest serving board members when Linda Mahoney died suddenly and unexpectedly of a heart attack. Linda had served on the MLAW board for 14 years. She was a passionate, committed advocate for women's issues and was an active participant in every rally and event. Linda was a leader of Maryland Now and a member of the Women's Legislative Briefing Planning Committee. She also supported many statewide and national candidates for political office who recognized her contributions to their success. But while she was a respected leader, she was also a worker who always stepped up to take on supportive tasks that keep an organization going. She always followed through and could always be relied upon. All of these qualities made her indispensable and irreplaceable. Linda was a wonderful person. She was kind, generous, and a supportive friend to me and to many others. Her accomplishments and widespread respect and love leave an enduring legacy. Please join me in taking a moment to remember Linda Mahoney. Thank you. Now we'll proceed to the agenda for the wrap-up. And how we're going to do this is that our board member liaisons who have worked on these bills throughout the session are going to present each of the bills, the ones that passed and the ones that didn't. And we're also going to ask those of you who were in lead groups or advocated for these bills, or who are legislators who worked on these bills or sponsored them, to make any comments or additions that you want to after each board member presents the bill. So we hope that there will be some dialogue and some opportunity to discuss what made them successful or perhaps why they didn't pass. So I'm going to go first to Karen Williams, who is going to introduce the first bill on the agenda.
Good afternoon, everyone. As Michael said, I am Karen Williams. I am representing Maryland Business and Professional Women on the board of directors. And I I'm taking Linda Mahoney's place, at least for this event. Linda was the MLAW liaison for the first bill, SB 505 and HB 277, criminal law, first degree child abuse, continuing course of action or course of conduct, excuse me. The the lead group is the Prince George's County State's Attorney's Office. And the legislative sponsors were Senator Shelley Heddleman and Delegate Vanessa Atterbury. So I may have some of this being new to this particular bill, the details of it, I may have it a little off, but if anybody has better information, please feel free to correct me. Anyway, so prior to the passage of this law, repeated child abuse, would come in, I think, basically as a second degree child abuse. And these are things with fractures, repeated abuse, burns, other injuries that could be diagnosed as torture by medical professionals. So these repeated injuries could only be covered by second degree child abuse, as I said, and not a crime of violence. In order to be a crime of violence, it had to be first degree child abuse. And the second degree child abuse statute basically put continuing child abuse on par with a misdemeanor second degree assault. So it's pretty much nothing and doesn't provide the same protections as a first degree child abuse does. So this bill was designed to change that and to show that if there's a continuing course of repeated abuse, whether it's fractures or burns, if they can show that it happened in multiple times, multiple events, then that should be considered first degree child abuse. First degree child abuse, I believe, well, it's a longer prison sentence anyway. There's some other issues associated with that. So the bill passed, and the new law says that first degree child abuse can happen or can be charged when there's 3 or more acts that constitute second degree child abuse. And they consider that showing a continuing course of conduct, which then will elevate it to the first degree. So they have to show that 3 courses or 3 acts were committed against a particular child that constitutes second degree in order to make it first degree. I hope that's makes sense to you all. It was a little confusing when I was researching it. I believe there was some discussion about the whole second degree child abuse concern, but ultimately they did agree on 3 instances, and it was signed by the governor. So we're very excited about that. I do not have any information on a next call, or do they have any plans to move forward to try to modify the law at this time? I would think if they want to, we may hear from them at our fall conference. So any questions, or is anybody from Delegate Atterbury's or Senator Heddleman's office, or even our lead group on the phone? I didn't see anyone as I was scrolling through. So I guess that will conclude my report unless there's some specific questions.
Okay, next up is Diana Phillip, who will speak on the bill that, in fact, her group MLAW sponsored.
Hi, I'm Diana Phillip with MLAW Pro-Choice Maryland. We were the lead advocates for public schools provision of mental health products requirements, Senate Bill 427 and House Bill 205. The lead legislative bill sponsors were Delegate Krill Resnick. This was his third time putting in this bill, and this year he was joined by Senator Sarah Elfrecht. This was a bill that actually was passed by the House last year, but because we adjourned 19 days early, ended up dying and was reintroduced again this year. The original bill talked about having at least one restroom in an elementary school be able to install size appropriate and free menstrual hygiene products such as tampons or pads. And in middle schools and high schools, at least two restrooms by October of this year, 2021, and all restrooms that were female designated by August of 2025. It also allowed at least one male designated restroom and anything that was gender neutral. However, the bill got amended out the male designated restroom and gender neutral. Matter of fact, elementary school got amended out, but then we worked on the bill again. And by the great leadership that we had of folks in the Senate Committee of Education, Health, and Environmental Affairs, and the folks we had in the House Ways and Means, we got a bill with funding, which is actually one of the problems with the bill was the idea of school districts being able to afford to install the dispensers. So now in academic year, actually budget year 2023, there's $500,000 being set aside to reimburse the school districts for installing the dispensers. So now the bill is in a position to be 1 year later, where at least it's at least one restroom in an elementary school and at least two restrooms in middle schools and high schools that are female designated by October of 2022. But by November of 2022, every school district needs to produce a plan and submit it to the Maryland State Department of Education about how much and how many dispensers they're going to install. So that way they can be reimbursed for those that are going to be installing the dispensers by that deadline. And then they've got until, again, August of 2025 to install all restrooms that are female designated in middle schools and high schools. And these are public schools. So the call for advocacy is among our young people, because remember, this is just the baseline. This is going to be the requirement. It's at least one restroom in an elementary school and at least two restrooms in middle schools and high schools, and then all the female designated ones by August of 2025. But the schools can do more. They can put them in male designated restrooms. They can put them in gender neutral restrooms. And so what we're asking folks to do, we had many young groups youth-led groups that were leading on this bill, which we're very, very pleased with. We worked with a national group, period, and there was many chapters across the state that were working like Be More Happy, period, and all sorts of student support centers. But we were also happy to see organizations like the Maryland State Conference of the NAACP and the Maryland Catholic Conference, along with medical advocacy groups such as American Academy of Pediatrics, and our education groups like Strong School Maryland and the Maryland State Education Association. So I think together what's going to happen in the next couple of years is that we're going to be able to prove that these dispensers can be installed in including male designated restrooms and gender neutral without any problems. And that we'll be able to come back in a couple of years and have that requirement in case there are school districts that are still reluctant to install those kinds of dispensers. And again, these are size appropriate, which is very important because there's a difference between the body of an 8-year-old and one who's 18 years old, and making sure that these youth get the supplies they need to stay in school on track to graduate and not miss class, not miss full school days, and not have to be subjected to any kind of discrimination or harassment from peers because they don't have access to these products. Thank you.
Are there any questions or any additions anybody wants to make? It's very complete. Okay, let's move on then to Joanna Diamond.
Hi, everyone. It is my great honor to present on HB 463, SB 172, the Maryland Health Equity Resource Act. For this bill, the lead sponsor in the House was Delegate Eric Barron from District 24 in Prince George's County, and the lead sponsor in the Senate was Senator Antonio Hayes from District 40 in Baltimore City. Actually, my senator in Baltimore City. And the lead group for this bill was the Maryland Citizens Health Initiative. So this bill would create a health equity resource community, health equity resource communities throughout the state. It was actually a really wildly successful initiative that had been in place with the previous administration, and it was brought back, at least in some form, for this session. The communities would incorporate areas with poor health outcomes that compete for grants, tax incentives, and healthcare provider loan repayment assistance to increase access to culturally competent care and ultimately reduce health disparities. Health inequities based on race, ethnicity, disability, and place of residence persist throughout the state, as shown in maternal and infant mortality rates and a number of other measures. Inequities are stark at the intersection of gender, race, and location. And in Maryland, for instance, Black mothers die due to pregnancy 4 times more than white mothers, with the disparity continuing to widen over time. The infant mortality rate for Black non-Hispanic infants is 2.5 times the rate for white non-Hispanic infants, with rates worse for rural Black infants than urban Black infants. Health equities resource communities would improve health equity, including for women. Communities would compete for grants, tax incentives, and other financial options to reduce these disparities. The purpose, as you may have heard from the description of the bill, is to 1, reduce health disparities, 2, improve health outcomes, 3, improve access to primary care, 4, promote primary and secondary prevention services, and 5, reduce healthcare costs and hospital admissions and readmissions. The commission itself, as part of the bill, will provide an interim report this December 1st, 2021, and then we'll have a final report to the legislature by January 1st of 2023. Procedurally, the bill, we're very happy to announce, has passed both the House and the Senate with bipartisan support. It is an emergency measure, so assuming it becomes law, it will take effect from the date it's enacted and will remain in effect until June 30th, 2023. The bill, which we do hope will become law, is funded also from 2023 to 2025. With $15 million per year, which is absolutely fantastic. It's certainly the reason why many bills die in the legislature, so we are thrilled that there is a funding mechanism for it. As far as next steps, it's important to note that Governor Hogan has not yet signed the bill. So it is not yet law. But we are very hopeful that he will sign the bill or simply will allow it to go into law without his signature. The jury is still out, but we are hoping that the governor signs this very common sense bill that will be a huge and tangible improvement to health equity in this state. As I said, the Maryland Citizens Health Initiative has been the lead sponsor and certainly the liaison for MLAW. And they will be organizing forums and in other ways letting folks know about the grants that are available under the Health Equity Resources Commission law, which we do hope will become law. They've been our close partners on this bill and can certainly keep you updated on their advocacy and efforts to ensure that this bill becomes law and implemented effectively. So thank you so much for allowing me to present on this bill, and to MLAW for prioritizing this agenda. It's an honor to be part of this board. And certainly if there's anyone from Delegate Barron or Senator Hayes' offices that are here, or anyone from our lead sponsor, happy to hear from them and take any questions.
Okay, if there are no questions, then we'll move on to Michelle Suri, who appears to be driving in her car. And you're muted. Can you unmute? Waiting for Michelle to unmute.
There we go. Am I still muted?
No, you're good.
Okay, great. So I'm not driving. I am, however, sitting in my car with my children having cross-country practice, but since it's been raining on and off, they asked us to stay for a little bit. And thus, here we are as women multitasking. This is kind of the story of our lives. And it's actually a very good, I think, introduction to the bill that I'm here to present. I'm very happy. I'm Michelle Seary, the Executive Director of the Women's Law Center, Maryland, and proud board member of MLAW. And I am very, very happy to be introducing SB 486, HB 581, which was the employment standards during an emergency bill, also known as the Maryland Essential Workers Protection Act. The sponsors of this bill were Chairman Derek Davis from the House and Senator Augustine, and the lead group was SEIU. And I don't believe I see the very wonderful and amazing Ricard Jones in the gallery, but if she is, I would love for her to chime in. But as many of you know, this past year with the pandemic, women were amongst the hardest hit. Economists have dubbed this the she session, which meant that women, for example, in the month of December of 2020, accounted for every single net job lost in this country. At the same time, women, particularly Black women and Latina women, were disproportionately representing a lot of the sectors that were hardest hit and in the most dangerous jobs, such as healthcare workers, direct care workers, and a lot of the food industry workers. So these are the folks, the essential workers that we were cheering for at night, that we were lighting up our windows for at night, and at the same time, they were not getting the protections in the workforce, despite the fact that they were going to work every day and risking their health and lives for us. So this bill aimed to address that, and I am happy to say that it did pass. It also has not been signed yet by the governor, but we are very hopeful that it will be. And it, like I said, it passed both chambers, and it is an emergency bill, so it would go into effect upon enactment. Now, the final version of what was passed is quite different than the version that was initially proposed, but it is still a very strong and meaningful bill. The bill will require the Secretary of Labor for Maryland to establish specific safety regulations known as an emergency temporary standard. That emergency temporary standard will require employers to notify the Department of Health of positive COVID cases, for example, within 24 hours, inform employees about positive cases, and apprise employees of their rights to report workplace safety violations. Looking forward, in the event of another pandemic, it grants essential workers access to personal protection equipment, to free testing, and the right to refuse dangerous work during public health emergencies. Now, unfortunately, there were certain provisions that were struck from the bill. So, for example, there was a $3 an hour hazard pay increase that was struck. There was they do require essential workers to provide documentation if they're going to use public health emergency leave. There was at one point no requirement for documentation, but that was added in, and it is unfortunately not retroactive. But nonetheless, I think all the advocates agree that it is really an important step forward to protect those workers that we all relied upon so much and continue to rely upon right now throughout the pandemic. So that being said, like I said, I'm happy to hear from Ricard if she's here, if anyone else is here from SEIU, or to answer any questions that folks might have about the bill. It was very important, and it's still really important that we support these workers.
Are there any questions? Any comments, additions? Thank you, Michelle. You're a good example of moms who multitask. Okay, so those were the 4 bills that passed. So now we're going to have a conversation about the bills that didn't pass. There were 3 of them. And I'm going to go next to Joan Stein.
Hi, I'm Joan Stein, and delighted to be with you this evening. I can't see all of you, but a lot of you I can see, so hi. The bill I'm going to talk about is Senate Bill 57 and House Bill 748, Family Law, Custody, and Visitation, a really important bill. The lead sponsors were Senator Susan Lee and Delegate Vanessa Atterbury. The bill requires the court in a custody or visitation proceeding to deny custody or visitation if the court has reasonable grounds to believe the child has been abused or neglected, and also reasons for the finding. It also authorizes the court to provide visitation under special circumstances. So what happened with this bill, it was the bills were heard on both sides, and a lot of work was done, as you can imagine, by the advocates or with the staff of the members of the committees. However, the committee ran out of time, and that happened with a lot of things this session. But it is likely, however, that they will come back next year with a different version. Now, what I'd like to ask, if there's anyone online from Senator Lee's office or Delegate Atterbury's who would like to add something to what I said, that would be great. Anybody here? I see Laurie Ruth. Does she have anything to add to this from the Women's Law Center?
Hi, Joan. Thank you. I mean, I think you stated it pretty well. This is a bill that arose out of a work group that was established in 2019 by statute to examine court processes when child abuse or domestic violence has been alleged. And what it was trying to do, as I said when I testified, was to give some actual meat to the statute that already exists to sort of, if I can say delicately, twist judges' arms a little bit to require them to actually address these allegations rather than just hearing them and dismissing them and never mentioning them again. So it was a very well-intentioned bill that came from the 24 recommendations that came out of that work group that I sat on the work group, and there were many other members of all different areas, a lot of child psychologists and child abuse experts and whatnot were on that work group. I think the problem with the bill was, in a sense, they were trying to do too much. And so, you know, when we saw it, the people who practice family law, sort of boots on the ground, practice family law every day, were like, this is not, it's probably not going to work the way it's drafted. So we worked really, really hard with Senator Lee's office in particular, in me and some people from the Maryland State Bar Association's family law section and some other people, to try and get it in a form that we thought would actually sort of hone it down and make it do what they were actually trying to do. And we got, I think, some good compromise language, but as you say, it just sort of ran out of time. And so, you know, it's not that unusual. Sometimes it takes, you know, well more than 1 year to pass a bill. I think that next year, hopefully we'll come back with a tighter, better version of it that will actually address, I think, you know, sort of a narrower spectrum of what they're actually trying to get at. So it was this great good faith effort, but maybe bit off a little more than they meant to in the drafting. That's how I would characterize it.
Thanks, Lori. I'm so glad you were here because it is really an important bill. So hopefully next year we can still get behind it and good things. Thank you.
Thank you.
Any other comments, questions? Okay, then we're going to go to Diana Rubin.
Hi, I'm Diana Rubin, and I represent the Montgomery County Commission for Women on the Maryland on MLAW board. And I have to say, chime in that the bill that I'm going to talk about, I feel, is equally important. I'm presenting on SB 211, HB 375, and the formal title is Labor and Employment, Family and Medical Leave Insurance Program Establishment, the Time to Care Act of 2021, which is basically paid family and medical leave. And anybody who's been through the pandemic and had to stay home and take care of children or older people or been sick with COVID, anybody who basically is alive knows that paid family and medical leave, there's no better case for it than the pandemic and what we've been through. Unfortunately, it did not pass, but just to give you a brief summary, the Time to Care Act establishes a family and medical leave insurance fund to provide partial wage replacement for employees who have to stay home to care for a new child, a family member's serious health condition, their own serious health condition, or a family member's military deployment. And in the House, it was introduced by Delegate Chris Valderrama, and in the Senate by Senator Antonio Hayes. And the lead group on this effort was the Maryland Family Network. And I have to say that the Clinton McSherry was the lead person, and he spearheaded the Time to Care Coalition, which met weekly to build support for the bill. And there's good news and bad news about the fact that it didn't pass. The bad news is that it didn't pass, but which everybody knows. But the good news is that they really did build support, which I think will help next year. They got a lot of labor unions and business on board. And, you know, one of the big problems, it's a boulder, you're pushing it up the hill. One of the big problems is that business, you know, is concerned about the cost and fears, you know, mandates on them. And even though there've been a lot of other states that have passed these laws, and there've been studies finding that paid leave is very actually good for business, especially for small business, that where it evens the playing field and makes a competitive advantage, so that Google and Amazon can't, you know, give paid leave and recruit workers away from small business. It's still something that they feel concerned about. So I think the fact that they were able to build business support and labor union support is actually a really good thing. And sometimes these new benefits take a while to build. So I don't know if Clinton's on the line or anybody from any of these legislators' offices, but I would love to hear more about that. And just let me back up and say that hearings were held both in the Senate Finance and the House Economic Matters Committee. And I'm hopeful for next year, because sometimes these things, like, they just take a long time to build. And so we do believe that there are legislators who are going to introduce this next year, as they did last year. And so we're looking for this to be on MLAW's agenda next year, because it's really something that women especially, we really need, and families need. So that's what I think. And thank you for making this a priority for MLAW. And I'd love anybody else who wants to weigh in. Any questions? Not that I could answer them, but thoughts? Is anybody on here who can shed any other light? And thank you to Clinton and the group. I'm sorry, the name just went out of my head. It's the Maryland Family Network, for their leadership.
Thank you, Diana. All right, we're going to go to Liz Joyce now on a bill that came very close to passing and disappointingly ran out of time at the end. Liz?
Hi, I'm Liz Joyce, a longstanding board member and the current vice president of MLAW. It is just wonderful to see so many of you here today. I guess the rain collaborated with our agenda, but whatever the cause, we're just thrilled to have you, and thank you. The bill that I'm going to talk about is HB 147 SB 250, the Love is No Defense Act, and the lead group on this was the Maryland Coalition Against Sexual Assault, and the executive director, Lisa Jordan, is on the line. So when I get through summarizing her summary, I'm hoping that she will chime in and give us some more background on the dynamics behind this bill. Essentially, in Maryland, it is allowed for certain sex crimes to be committed in marriage. Marriage is a defense against being charged with certain sex crimes. And this bill is an attempt to remedy that. The House Judiciary Committee and the House passed it very smoothly. However, once it got to the Senate and the Judicial Proceedings Committee started hacking away at it, the amendments that were proposed were so objectionable that it didn't make it through out of the committee. So I hope Lisa can give us some more information on that. The sponsors in the House were the sponsor was Delegate Charlotte Crutchfield, and the senators were Susan Lee and Jeff Waldstreicher. And we particularly appreciate their help, and Delegate Emily Shetty, who did a great job. And if you have an opportunity to thank them, let's do that. And Lisa, do you have any interesting background to share with us about this?
Thank you so much, Liz, and thank you to MLAW. It's always a real pleasure to be part of MLAW, and you really are an amazing group, and your grassroots activism helps so many women across the state, so many kids, so many families. It's really a fabulous grassroots effort. So thank you for that. I think that at the end of the day, this is a bill that we really just need to stand very firmly on. There simply should be no giving ground to the principle that your right to say no should not vary according to what relationship you're in with your partner. And there was a disagreement about that. There were people in the Judicial Proceedings Committee who just really feel that marriage is a contract that includes a contract to have sexual touching, and that they didn't want to change that bedrock principle in their view. And I hope that we are all able to say no, that whether you can say no or whether you can consent should not depend on whether or not you're married or whether or not you're in a sexual relationship. I can add a little bit of color to what Liz was saying, and say that the amendment that they proposed, the language was just really fraught. Also, it talked about whether it would be okay to have physical contact commonly engaged in by two individuals in a sexual relationship. And who knows what that means? Like, what is a commonly engaged in contact? And the other was that, you had to reasonably indicate that further physical contact is unwanted, which was also disturbing, because it suggested that maybe there were some ways to unreasonably indicate no. I think that the other thing that happened is there really was a fundamental misunderstanding about Maryland's law right now. Maryland is not an affirmative consent state. So you don't have to physically resist anymore, but you do have to resist. And so there was a hypothetical that was brought up time after time after time about someone reaching out and sexually touching their wife and becoming a criminal. And that's not the law now, but it is the law. If you're not married and you say no, then that's a crime. The problem is the law right now says if you are married, then that's not a crime. And that's what we need to fight against. That's what we need to stand up for and pass just a complete repeal. It's not that hard, people, just a complete repeal.
Are there any other comments or questions about this bill? Joan?
Not about this bill, but I checked the chat, and Gloria Stein, I don't know if she's still with us. But,
am.
Oh,
And,
good.
Okay.
So you had a comment about the custody and visitation bill.
Exactly, and thanks for asking, Joan. I am actually from Florida, but I have two daughters in Maryland, and I'm a member of Montgomery County now when I go back and forth. My situation is that my granddaughter 30 years ago was not believed when her father molested her at 3 years old. He was given unsupervised visitation by a lousy judge in whatever the county is for Key West. I forgot already. But that was during the time that Phyllis Chesler wrote the book Mothers on Trial. And it's a damn shame that we have to deal with this on and on and on. And it's a shame that this bill just doesn't get passed considering the children. So that's what I needed to say.
Thank you so much. Glad you feel the way I do.
Oh, it's very sad. It's just very sad and scary.
We've got next year. Thank you, Gloria.
You're welcome.
So Gloria, if I could just comment, on that work group, we saw a presentation by a law professor named Joan Meyer from George Washington School of Law, who's done this research that essentially shows that if it's a little hard for me to do it quickly, but there is research that supports the concept that when women allege domestic violence, they are more likely to lose custody. And if they allege child abuse, they're even more likely to lose custody. And I don't want to overstate it because I haven't read the report in a long time, but it was really disheartening. I think it's based in a deep misogyny it's nationwide. She did a nationwide study, and it's judges who think that women lie. And that they're making it up in some way. And it was really hard to listen to, quite honestly. But the problem with the bill was, or at least some of the criticism with the bill was that, yes, it's trying to give some teeth, like I said, to the specific provision in our family law that says if domestic violence or child abuse is alleged, the court must address it before they can go on and make any other determination about custody. And from my perspective, what I see so much working with a lot of unrepresented people is that courts make rulings and the litigants have no idea why. The judge doesn't necessarily have to articulate why they did what they did. And so at the very least, that SB 57 would require the judges to articulate on the record why. Like, even though it's the third time CPS has investigated him for, neglect of the child or sexual abuse of the child or whatever, what have you, I'm still going to give him custody over mom. It would be nice to hear the judge have to articulate why. And maybe that would start helping those really complicated cases. There were some companion bills to that bill that weren't, I don't think, even put in front of MLAW for voting. I can't recall anymore, that would do some other things that might help. But, I'm a little bit of a cynic. And at the end of the day, I don't think judges get on the bench and think they're making the wrong decisions. So they think they're doing the right thing. And so the question is how to educate them and get them to understand the current social science about what this does to children put in this situation. And I'll get off my soapbox now. Thank you.
But can I comment again? I belong to Palm Beach County now, here in Florida, and we have a group called Mothers Against Travesties. Facts, Families Against Court Travesties. And I'm a court watcher. And we go into the court, they allow us in, and we watch what the judges do and say. It's mostly effective when we are able to confront the system. And a lot of the times the lawyers are at fault also. So I just wanted to say that you guys, if you could do that too, and get a bunch of court watchers. We wear badges, they know who we are, and they know we're watching. So that's important.
Thank you all very much. And if you have something to add, would you put, like somebody had a reference and I didn't catch it, but if you would put that on the chat, that would be much appreciated. Thank you. Thanks for your comments.
Are there any other comments about or questions about any of the bills that we've talked about that either passed or failed? Okay, I'm just going to mention the 2 overrides. And if anyone is here from the groups that supported those, feel free to jump in. But the 2 bills that were vetoed by the governor last year and were overridden this year were the public safety, rifles and shotguns, sales, rentals, and transfers. And the second one was correctional services, pre-release, unit for women, facilities and services. Is anybody here from any of the groups that supported those? But we're happy to say that those vetoes were overridden. So that's great news. Okay. Are there any other questions? Any other comments? Okay. Well, then I would suggest that you raise a glass and toast the successes that we had this year. You have water, tea, soda, wine, and join us in celebrating a pretty good year. In spite of the ones that we didn't get, we certainly had a good year with the ones that we did. So to everyone who worked on these bills and made them a success, Here's to you. Okay. And we're moving ahead right on time. We had planned this to be about an hour, and I think we're right on schedule. I'm now going to turn this over to Board Member Shruti Etneger, and I'm sure I just messed up your name. I'm sorry, Shruti. Who's going to talk about MLAW and things that we're doing.
Thank you, Michael. Good evening, everyone. My name is Shruti Bhatnagar. I serve on the board of MLAW and live on the occupied land of the Piscataway Drive in Montgomery County, Maryland. On behalf of the MLAW board, I thank each and every one of you once again for joining today's legislative wrap-up happy hour, and hope you enjoyed celebrating the work MLAW has done in the 2021 General Assembly session. We appreciate your support and taking action to help MLAW pass legislation and policies that impact Maryland women and families. Your participation during the legislative session was critical to our success and the work that we need to do continuing moving forward. I'm proud to be a board member of MLAW and its commitment to embrace diversity and be inclusive. MLAW encourages participation from individuals and organizations that bring a unique and valuable perspective to the work we do. If you are not a member of MLAW, please join. Your membership empowers you to vote on which bills MLAW should support in every General Assembly session. As a member, you will receive regular updates and be able to participate in MLAW's action alerts. As a member, you will have a strong voice in advocating for these issues that you care about. Please visit our website to become a member and join our mailing list. We also ask that you share this information with your network, family, friends, and colleagues, and encourage them to join and support MLAW. This will help create a greater awareness of these issues that are important to all of us, and also strengthen the impact that MLAW can have in helping pass laws in Maryland. I'm excited to announce that following our conversation from the Fall 2020 conference, MLAW has launched its own YouTube channel and podcast. Please check out our website and listen and look at the link in the chat to listen to the conversations that are available, and subscribe to our YouTube channel to get notified on the upcoming episodes that will be available this summer. Lastly, I would be remiss not to mention during this month of May that is celebrated as the AAPI Heritage Month that MLAW supports the movement on Black Lives Matter and anti-hate against Asian American Pacific Islander communities. Thank you again for your continued support. Don't forget to listen to MLAW podcast series and have a wonderful summer. And with that, I am going to drop the links in the chat. Thank you, everyone.
Thanks, Rudy. Thank you all for participating in this virtual wrap-up. I would like you all to mark your calendars for the fall conference that we will have on Saturday, November 13th. And I can't tell you right now whether it will be virtual, but I hope it will be in person. I think we're all eager to see each other again. And if that's the case, the plan is to have it at the Silver Spring Civic Building. But we'll let you know with upcoming emails and other announcements more about that fall conference. But mark your calendars for that date right now, and we hope to see you there, and preferably in person. That wraps it up for us. Are there any comments or questions that any of you still have? All right, thank you all. Please, MLAW board members, please stay on the line. We're going to have a board meeting following the wrap up. Thank you all. Bye-bye.